Hey everyone, welcome back to the channel. We've got 3 wild courtroom moments lined up for you today, and trust me, each one is worth sticking around for. First up, we're heading into Judge Shackelford's courtroom, though this time there's a temporary judge sitting in, and honestly, they sound almost identical to Judge Shackelford himself. After that, we've got 2 cases where some less than stellar courtroom behavior ends up landing people exactly where they didn't want to be, behind bars. Let's jump right into it.
Morning, Your Honor. Jeffrey Fant on behalf of Ms. Hall. Wait formal readings stand new. Request matter be set for settlement conference and discovery order to enter.
Ms. Hall, can you say your name for me, please?
Alyssa Hall.
Did you go through your advice of rights with your attorney, Ms. Hall?
I did.
Okay. Did you have any questions about your constitutional rights?
No,
And did you allow him to sign your name to your advice of rights?
I did.
Okay. And so in front of me, I have an order for discovery. I will have that signed. We're going to be adjourning this for a settlement conference for your attorney to get the discovery or all the evidence that the other side has. For purposes of arraignment, I'll enter a not guilty plea. Ms. Hall, you're going to have some bond conditions. You're to appear in court as directed. You have a $1,000 personal bond. I think I missed that. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any crimes while released. And you're to immediately notify the court of any change of address or phone number. Give me just 1 second.
I do have a question on that. My bond was returned to me.
You don't have to post any money.
Well, I know that, but I thought all bond conditions were done because the bond was returned.
Well, Ms. Hall, we're doing the arraignment now, which is we hadn't done before. So she's going to give you the bond conditions, but the bond, the monetary bond is personal, means you don't have to post any money.
But you still have to adhere to the bond conditions I just stated. Do you understand? Yes or no? Do you understand, or do you need me to go through them again?
I suppose.
It's a yes or no question, Ms. Hall.
I don't understand how there is still bond conditions when my bond was returned, but that's apparently something else according to my lawyer. So it is what it is.
No, I'd be happy to explain it to you. So you're on bond. So whenever you have a pending case, you are out on bond. Instead of being in custody, you're out on bond. I'm giving you a personal bond, which means you don't have to post anything, but you still have to adhere to your bond conditions.
Not exactly. See, you can't just go out and commit murder when you don't even have a pending case. But when you do, something as minor as a disorderly conduct charge can be enough to get your bond revoked. In this case, she was originally arrested for domestic assault, bonded out, had the charges dropped, only for them to get picked right back up again. So what we're watching here is actually her second arraignment on the exact same charge.
I originally got that bond back and told that nothing further was going to happen. And then all of a sudden I was told I missed a court. So I'm still confused. Is this not the same case?
Okay, so we're going to do a full arraignment. Okay, Mr. Panto?
I'm just confused.
I understand. I'm going to go through it with you. Because that's part of the arraignment, is to understand what you're being charged with. So give me 1 second. Let me
I'm
pull
being
up
charged for disorderly conduct at my brother's house. I understand that.
Okay, that's the
But
charge.
the day my bond was returned and they sent a letter stating nothing is going to happen at this time. And then
They have the right to review and file charges, which they did, and that's why we're at today's point.
all right, can we
so they reissued the charge, and I'm reassessing a bond, which means you have bond conditions because technically you're out on bond. I'm assessing you a $1,000 personal bond, which comes with bond conditions. So I see where you will get confused if the one before got returned to you, but we're back at it. They reissued this case.
I just don't even understand how they reissued the case because it was my brother kidnapped my kids, but it is what it is. I have my own issues with Taylor Police Department and everything else right now that I'm going through. So.
Okay, well, you're the one that has the case. So you're the one that has the bond conditions in the jurisdiction of this court, Ms. Hall. Do you understand your bond conditions, yes or no?
Yep. I know that my lawyer requested discovery, but I
I'm
would
not
like,
talking to you. There's no question. So give me 1 second. I'm looking the report over.
Ryan Lupica is the.
Is there a place?
There's an address.
That's what I'm looking for.
It's Ryan
it's on
Lupica.
Marvin Street in Taylor.
Ma'am, give me a second, okay?
And this is why I hate Taylor.
I did explain to her that the court would require she have no contact with Mr. Lupica or his address.
Yeah, I just need for the
I
bond
don't talk to
condition.
my brother.
Ma'am,
Okay, no,
enough.
don't talk.
Honestly, you're just digging yourself a hole right now, so just stop.
I'm not doing anything.
Ms. Hall, it's easy here.
Marvin Street.
Yes.
Okay. Okay, you're also to have no contact with Ryan Lupica or 13685 Marvin Street. When I say no contact, Ms. Hall, I mean no contact. That means you cannot email him, call him, or text him. That means nobody can do those things on your behalf. I see you're listening, but I don't need the attitude. You cannot send a text message, a tweet, an instant message, or anything of the like. That includes contact on Facebook, Instagram, Twitter, Cash App, or any form of electronic communication whatsoever. If you have him added on any form of social media, you are to delete him immediately. Sending a blank message is considered to be contact, since I'm instructing you to take specific steps to make sure that does not happen. If the communication comes from you or by the direction of you, it will be considered contact, and it will not be a defense that you accidentally contacted him. If he contacts you, you are not to reply. If he's at a public place, such as a store or a park, and you see him, you are to leave immediately. This is the order of the court. The victim in this case cannot change the order, only a judge can. If he were to invite you over or to ask to meet you anywhere, and you do so, that is a violation of this court's order. If we need to change this order at any point, we will have a hearing with both parties present. Do you understand that?
Yeah, my brother's dead to me.
I'm sure your brother's enjoying the peace and quiet that comes with you keeping your distance. Now do yourself a favor, stay away from him, listen to your lawyer, and maybe drop the whole petulant toddler act before you end up like the next guy who got himself arrested at his own pretrial hearing.
All right, Mr. McGregor, this is cause number CR 24172, and we're here on a status hearing regarding your hiring an attorney. Tell me where you're at on that.
Yes, sir. I had brought the paperwork that I needed to prove contingency. I brought the pay stub and the worth of my car. And right now I'm in between jobs, so I got approved for unemployment temporarily until I can get another job. I'm just waiting for those deposits to come through because sometimes they take a while to review. So currently I'm waiting for that to.
Do you know how long that's going to take?
Usually they said about 6 weeks sometimes to receive payment, but I'm still looking at jobs and I've got a few interviews scheduled as well. So
When are your interviews scheduled?
today and this weekend or tomorrow.
So we've had this conversation before, and I've told you that you've applied, and I've looked at your reapplication, and you still make more money than the minimum to have a court-appointed attorney. You understand that? Because you've reported that you have zero expenses. Because didn't you say you live with your father or something? Do you live with your father?
Yeah,
He pays all your expenses.
he does.
So all the money that you make can go towards an attorney. The value of your car can be sold. It can go towards an attorney.
It's only worth $1,300.
Well, I understand, but if you've got $3,000 in benefits coming to you, you've got $1,300 in a car, and you've got no living expenses, then all you have is income and no debt. And so state law says that it's going to have to be less, that your income is going to have to be a certain level above your expenses before the court is going to be able to find you indigent. So we had this conversation last time that you may have to sell your car.
But $1,300 doesn't help me.
What kind of backwoods math are you working with here? If you need 10 grand and can sell your car for $1,300, That means you're really only short about $8,700. The smarter move would be to get off your lazy self, find a job, and use that $1,300 car to actually make some money. Maybe then you could afford a lawyer instead of complaining about it.
$100 towards that 10,000.
They haven't released the funds at all, and they're basically still reviewing. And the only money I had was the $111 from Abby's Bagels. So that didn't last very long because I asked them questions about their policy and they said that it wasn't working out. So
How much are you paying your bondsman?
paying what?
How much are you paying your bondsman?
The bondsman, I paid $5,000 total. But that was when I had a job. HEB supplied my ability to pay. That went away because they took hours away and I was driving too far. So I've been kind of up and down with jobs. Like I've had 3 jobs the past year and none of them have worked out very well. Just due to scheduling of new employees and overstaffing, things like that.
All right, Mr. McGregor, I'm going to reset you for 2 weeks. Reset you for 2 weeks. I want you back here on October 17th. You come back and you still have a car and you still have income and you have no expenses and you come back without a lawyer, we're going to have a hearing on your bond. I may find your bond insufficient that day and I may put you back in jail. And the longer you sit in jail, more likely you're going to become indigent to the point where I can appoint you an attorney. You see how that works? If you're going to pay your bondsman $5,000, you're going to have a job, you're going to pay them $5,000 and you're going to get out of jail, but you're not going to hire an attorney to go forward on your case.
I would hire an attorney if I had 10,000 to come up with, but it's just not possible for me.
You've got a car and you're unemployed, right? So you've got a car, so you could drive to all these different places that are all looking for people to hire, right? Sounds like it's possible to me. So I want to see you back here in 2 weeks. If you don't have a lawyer in 2 weeks, then we're going to discuss.
All right, that seems fair enough. The judge is giving him a shot to sort out his lawyer situation, which, by the way, is tied to some pretty serious charges. But even though he's clearly frustrated about the mess he got himself into, he manages to make things worse. As he's walking out, he does something that instantly ticks off the judge. And just like that, he's arrested right there in the courtroom.
Bring him back in here when you get a chance, Fabio. Oh, yeah. Mr. McGregor, you've just disrupted court with your behavior today and your actions. You understand that?
I accidentally tried to overlap the wrong way. I apologize.
I'm going to find your bond insufficient today. Deputy Martinez, go ahead and take him into custody. Mr. McGregor, I'm going to appoint you an attorney.
So I might as well have stayed in jail, basically.
But you're going to jail now, and I'm going to up your bail to $150,000, and I'm going to appoint you an attorney.
150,000.
Yeah, that's what I said. 150,000, $150,000.
For opening the door the wrong way?
No, not for opening the door the wrong way. Do you want me to hold you in direct criminal contempt and sentence you to 6 months in jail, day for day, on top of a child charge that you have? Do you want that? Yes or no? No? Okay.
I apologize.
Okay. Well, it's done. What's done is done. You'll learn your lesson, I hope. All right. Go ahead and take him, and I'll send over an order.
Bye, have a great time. Well, that's certainly one way to qualify for indigent status. Now, let's move on to our next hearing. This one's about a guy out on domestic violence charges who just can't stop violating his bond conditions. And to top it all off, he decides to say something you should never say to a sitting judge, especially while standing in that judge's own courtroom.
Weathers, please.
Good afternoon, Your Honor.
Good afternoon, Ms. Conley.
Did you guys need Weathers, or what was the last name?
Yeah,
Weathers.
that's my turn.
Okay.
All right, thank you. You are Casey Lee Weathers, is that correct?
Yes, sir.
All right, Mr. Weathers, I'm Judge Elsenheimer. I'm handling this matter today for Judge Hamlin, who's unavailable. This is an arraignment on a motion affidavit and bench warrant that was requested by the prosecutor's office in Grand Traverse County. And sir, you should understand that, well, before we get to that, let me identify who's here. On your behalf is your attorney, Ms. Conlon. Ms. Copeland is the court reporter. Ms. Henry is the clerk. Mr. Olson is here from the prosecutor's office as well. Sir, the allegation against you is that you had positive test results on the 13th and 15th of October. You had a testing regimen that was part of your bond. The allegation is that you violated your bond, and violation of a bond can be considered to be contempt of court, which can be handled criminally or civilly. If it's handled criminally, it's a separate criminal misdemeanor, carries up to 93 days in jail, a fine of up to $500, but you'd have all the same rights you have in every other criminal case, including the right to an attorney. If you can't afford an attorney, one would be appointed for you at the public's expense. You also have the right to a trial. At that trial, the prosecutor would produce evidence to establish that you violated your bond. The standard of proof is beyond a reasonable doubt. You'd have the right to present your own defense, and if you needed someone to appear, I would order that to happen for that defense. If I thought that the prosecutor or Judge Hamlin thought the prosecutor had met that burden, he'd find you guilty. If he thought they did not, he'd find you not guilty. Ms. Conley, you've had a chance to discuss this matter with your client, correct?
I have, Your Honor. Thank you. Mr. Weathers would admit to the alleged violations at this time.
All right, thank you. So, Mr. Weathers, your attorney indicates that you're going to accept responsibility for the violations on those 2 dates. Is that correct?
Yes, sir.
All right, please raise your right hand. You solemnly swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, sir. I don't want you to talk about the domestic violence charge against you right now, third offense, or I suppose it's third or subsequent. We're not going to talk about that at all. We're only talking about this bond matter. Do you understand?
Yes, sir.
All right. The allegation is that you had test results on the 13th and 15th that were positive. It looks like they were positive for alcohol. Is it true that you used alcohol on those 2 days?
Yes, sir.
All right. So no surprise to you that you violated that you had positive tests on those
No,
days?
sir. Just
correct?
bad decisions, bad choices. That's it.
All right. I understand. All right. It's clear to me that you did violate your bond. I'm going to so find. Let's go ahead and have a conversation regarding bond going forward. Ms. Conlon, we'll start with you.
Well, Your Honor, Mr. Weathers has been on bond since on or about July 22nd. He's been compliant with his bond conditions up until these violations. He did, and he and I had a talk about this, Your Honor, when I got the bench warrant, and he admitted freely to me that he did relapse to alcohol. He had some stressors going on in his life, and unfortunately made a bad choice to drink, and he'd be the first person to tell you that. But other than this, he has done quite well on bond. He has not violated the no contact order at all. And he's been compliant with all of the terms. And he did turn himself in on the warrant, Your Honor. He is employed. He has jobs he can get back to if he's released. We do have a final conference in this matter on November 8th, and then we've got trial dates in December. So we'd respectfully request, Your Honor, that bond be reinstated with whatever conditions the court would feel appropriate to ensure that Mr. Weathers does not drink again, including a cam unit. He will gladly pay for and wear a cam unit till we get this matter resolved in order to be free to work.
All right, thank you, ma'am. Let's go ahead and hear from the prosecutor, Mr. Olson.
Your Honor, I would note that the violation report indicated that the defendant drove off after providing a positive PVT. He was very close to the legal limit. We would have concerns about that. We would ask the court respectfully to impose a cash bond on this case. His bond was modified on September 27th to include additional conditions of no alcohol consumption testing. We did request a tether at that time. The court denied that on the basis that the check-in app has location data, but we would respectfully ask for a cash bond as well as a cam unit that the defendant be required to wear.
All right, I'm concerned about even releasing the defendant whatsoever in this case. Looking at the reports that came in with regard to his testing, the prosecutor is correct. On the 10-15 date showed him at a 0.077 level. Maybe the defendant wasn't driving, but the indication from New Directions is that he left the parking lot at a high rate of speed in a dark Dodge. The indication also is that he was belligerent during the testing, that he did not comply with the urine screening, was unable to produce a specimen. I've got concerns about whether or not this defendant takes seriously his obligation to test. This is not a joke.
Absolutely.
Hold on.
Okay, yes, sir.
Hold on. This is not a joke. This is not something that is voluntary. This is not just a attempt to touch base with you and see how you're doing. This is a order of the court. And if you don't comply with it, then you can be held in criminal contempt, which is another 93-day misdemeanor. And frankly, you are getting awfully close to looking at that kind of response here. Having said that, I do think that there is an opportunity here to safely monitor the defendant and to keep the public safe as well. I'm going to go ahead and grant the defendant bond. I'm going to require that it be a cash bond. It's a $2,500 cash bond. I'm also going to require that he wear a cam unit that will test his alcohol. If he tests positive at any time or there's any issues with that cam device, then it'll be certainly my recommendation to Judge Hamlin or any other judge reviewing that he be held until this matter is ultimately resolved. These are serious charges. These activities are serious. At least there's some evidence, hasn't been proven, hasn't been charged. You may have driven pretty close to being drunk. So I've got some real concerns about this, and I think that we need to keep a tight rein on you until this matter is ultimately resolved. If you have issues with my bond decision, you can bring them up to Judge Hamlin. I'm sure he'd like to hear from you. Is there anything else that we can address with regard to bond, Ms. Conlon?
Not for us, Your Honor.
Okay,
Can I speak to an attorney?
Mr.
Maybe we have a breakout room.
I'll allow you to do so. Let's go ahead and put Mr. Weathers in this. We lost everyone for a moment, but Mr. Weathers back along with his attorney. They've had a chance to speak. Was there anything else, Ms. Conlon, that we needed to address for the defense?
No, Your Honor. Mr. Weathers was just wondering if you would consider a 10% bond for him as he's unable to post the $2,500.
All right, let's go ahead and hear from Mr. Olson as to the modification of the bond request. Mr. Olson?
Judge, we would oppose that. In addition to that, Judge, I would also ask that I believe this is an original condition of his bond, but we would ask that this condition be applied both in and out of custody, that the defendant not have any contact with Emily Weathers, who's the victim in this case, to include through third parties or electronic communications.
That is, if it isn't, it should be, and is ordered to be an element of his bond in this case. I think, frankly, given the circumstances, that the bond level that I set was appropriate and proportionate in this case. It's sufficient to guarantee compliance. As a result, I'm going to leave that bond level where it is. So it looks like we're all set. Otherwise, Mr. Weathers, I'm sure that Mr. Judge Hamlin will see you soon. All right, take care, everybody.
Thanks, Your Honor.